Yeah, I still just want to holler at you, though. You know what I'm saying?
I appreciate you.
You know that. Yeah.
Good to see Lil Durk in good spirits, but I don't know after this. Y'all see the whole gang is in there, right? Alrighty. So, attorneys for plaintiff United States of America, District Court, United States of America plaintiff versus Durk Banks and everybody else. Stipulation regarding requests for 1, continuance of trial date, and 2, findings of excludable time periods pursuant to Speedy Trial Act. Current date trial, 4/21/2026. Proposed trial date, August 20th, 2026. Plaintiff, United States of America, and defendant DeAndre Dontrell Wilson, defendant Wilson, both individually and by and through his counsel of record, Craig A. Harbaugh, defendant David Brian Lindsay, defendant Lindsay, both individually and by and through his counsel of record, Robert A. Jones and Tillit J. Mills, and defendant Asa Houston, both individually and by and through his counsel of record, Shafi Moil, stipulating defendants hereby stipulate as follows. So the court officially moved the freaking date. But we got to kind of get into it because it gets a little messy. There's things that are hidden that people ain't finding out or ain't looking forward to. But y'all know we got y'all locked right here. Hit that like button like you like something, and let's get on to it. We all about making money on Mondays, right? So while you going through your phone and chilling and playing games for free, it's time for you to get paid up to $500 a month with free cash. Yeah, that's free cash. It's Steady Nash gonna put $5 in your account specifically. Soon as you put that doggone QR code in, or you tap that link in the description, add the app on your phone and get to playing today. The number two of them. Number 2. App in the Apple Store, number 3 in the Google Play Store for a reason. Read the reviews before you do. Don't take my word for it. I'll catch y'all there. Let's get on with the content. Speedy Trial 2, failure to grant the continuance would be likely to make a continuation of the proceeding impossible or result in a miscarriage of justice. 3, the case is so unusual and so complex due to the nature of the prosecution and the number of defendants that it is unreasonable to expect preparation for pretrial proceedings or for the trial itself within the time limits established by the Speedy Trial Act. And 4, failure to grant the continuance would unreasonably deny defendant continuity of counsel and would deny defense counsel the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. Defendant Banks does not join in the stipulation to continue the trial in this matter. Nonetheless, the stipulating parties agree that pursuant to 18 U.S.C. 3161H6, the time period from the date the stipulation is filed, August 20th, 2026, inclusive, constitutes a reasonable period of delay for defendant Banks, who is joined for trial with co-defendants as to whom the time for trial has not run and no motion for severance has been granted. So it's just saying the case keeps getting moved forward and forward and forward and forward and forward to the point where you throwing these foes up, bruh. God, dog. And that's why some people are saying, oh, they're wasting their money. It's not Durk wasting his money. It's the fact Durk ready to go now. And they just ain't. The first superseding indictment in this case was filed on November 7, 2024. Defendant Banks first appeared before a judicial officer of the court in which the charges in this case were pending on November 14, 2024. The Speedy Trial Act 18 U.S.C. 3161 originally required that the trial commence on or before January 23rd, 2025. Defendant Wilson first appeared before a judicial officer of the court in which the charges in this case were pending on November 15, 2024. The Speedy Trial Act 18 U.S.C. 3161 originally required that the trial commence on or before January 24th, 2025. Defendant Houston first appeared before a judicial officer of the court in which the charges in this case were pending on November 21st, 2024. The Speedy Trial Act 18 U.S.C. 3161 originally required that the trial commence on or before January 30th, 2025. Defendant Lindsay first appeared before a judicial officer of the court in which the charges in this case were pending on November 22nd, 2024. The Speedy Trial Act 18 U.S.C. 3161 originally required that the trial commence on or before January 31st, 2025. On November 14th, 2024 for defendant Banks. The court set a trial date of January 7, 2025. On November 15, 2024 for defendant Wilson, the court set a trial date of January 7, 2025. On November 21st, 2024 for defendant Houston, the court set a trial date of January 14, 2025. On November 22nd, 2024 for defendant Lindsay, the court set a trial date of January 14, 2025. On January 2nd, 2025, the court continued the trial date to October 14, 2025 for all defendants and made relevant excludable time findings under the Speedy Trial Act. The second superseding indictment was filed as to all defendants on May 1st, 2025, which means, bruh, y'all should have just took that shit to trial right there. Damn, y'all would have dodged a shit ton of charges, but whatever. On September 17, 2025, the court continued the trial date to January 20th, 2026, and made relevant excludable time findings under the Speedy Trial Act. On January 13, 2026, the court continued the trial date to April 21st, 2026, and made relevant excludable time findings under the Speedy Trial Act. All defendants are detained pending trial. The government estimates that its case in chief will last approximately 2 to 3 weeks. All defendants are adjourned for trial, and a severance has not been granted. By this stipulation, the stipulating defendants moved to continue the trial date to August 20th, 2026. Additionally, the parties moved to set the following pretrial schedule. Defendants' reciprocal discovery deadline, July 30th, 2026. Motion in limine, including motions regarding experts. 1. Motions due June 29th, 2026. Second, oppositions due July 13th, 2026. Optional replies due July 20th, 2026. 4. Hearing date pretrial conference July 28, 2026. This is the fourth request for a continuance. The stipulated defendants request the continuance based upon the following facts, which the parties believe demonstrate good cause to support the appropriate findings under the Speedy Trial Act. The parties include counsel for defendant Banks, met and confer regarding the proposed briefing schedule and deadlines set. And that's further demonstration. It's like if you're getting ready to go to a boxing match, all right, we gonna fight. We gonna fight. All right, we gonna fight. All right, I need to do my training camp. Damn, it's so much stuff happening in my family. I can't train. Well, the other person, they ready to go, but shit, if you can't train, it's unfair. So it's basically saying, yo, judge, this is unfair. This will lead to a lot of BS. So the feds have nothing but time on their hands because where are all the defendants? They're all locked up. So with that being said, it just makes the most sense that they go, oh shit, all right, cool. Well, everything is locked up. Everybody's locked up. Shit, we can go discover, because the feds ain't gonna fight this. The feds having more time to essentially find more snitches and more clues? Man, hell no. In light of the foregoing, counsel for the stipulating defendants also represent that additional time is necessary to confer with defendants, conduct and complete an independent investigation of the case, conduct and complete additional legal research, including for potential pretrial motions, review the discovery and potential evidence in the case, and prepare for trial in the event that a pretrial resolution does not occur, which means people start taking deals. I just want y'all to know that. Defense counsel represent that failure to grant the continuance would deny them reasonable time necessary for effective preparation, taking into account the exercise of due diligence. The stipulated defendants believe that failure to grant the continuance will deny them continuity of counsel and adequate representation. The government does not object to the continuance. The requested continuance is not based on congestion of the court's calendar, lack of diligent preparation on the part of the attorney for the government, or the defense, or failure on the part of the attorney for the government to obtain available witnesses. For purposes of computing the date under the Speedy Trial Act by which defendant's trial must commence, the parties agree that time period from the date the stipulation is filed to August 20th, 2026 inclusive should be excluded pursuant to 18 U.S.C. 3161 H7A H7B1, H7B2, and H7B4 because the delay results from a continuance granted by the court at defendant's request without government objection on basis of the court's finding that, one, the ends of justice served by the continuance outweigh the best interest of the public and defendant in a speedy trial. Y'all want to know what that really means? They still digging through the freaking evidence. And they're not done with their other cases, which means they're only like getting the brief done. So they haven't even had a chance, meaning the other lawyers have not had a chance to sit up here and basically go, oh shit, well, we want to review all of this stuff. No, they're trying to say, we ain't reviewed it yet. Y'all put a lot of stuff out there. Drew and Brian Steele and Marissa Goldberg, they work for Lil Durk. Everybody else is still trying to get out too. So they basically saying, we got a lot of shit we got to get through, bruh. We not going to make it in time that y'all want us to make time. You know what I'm saying? Make it make sense. So as we get to page 9, DeAndre's attorney basically says he informed his client of his speedy rights. To his knowledge, his client understands the rights and he waives them, so he doesn't want to do it. So it says, I read the stipulation and have carefully discussed it with my attorney. I understand my speedy rights trial. I voluntarily agree to the continuance of the trial date and give my right to be brought to trial earlier than August 20th. We go down and we can see David Bryan Lindsay's attorney, and we can also see Asa Houston's attorney agree as well. And that's everybody agreeing. Is what it is. Not necessarily everybody, but, you know, the 3 who did. And it's granted. Because you can't prejudice, you can't hamper, you can't make them ineffective counsel by basically hamstringing them because you presented so many terabytes of information and so much bullshit that they got to sift through, so many motions that they had to do, so many things that they're going to, dare I say, get kicked out of the trial. See, one thing for certain, 2 things for sure. People believe in the superstar lawyer, right? The Drews, the Brian Steeles, right? But we forget that, or Joe Tacopina too, but I think Joe Tacopina is a drag down fighter type of lawyer. Like, to me, he's just on the fly, but that's neither here nor there. What they believe is this: yo, we got this. Meaning the crowd believes that Drew and Brian got this. What they fail to remember is Marissa Goldberg is damn near just as good as Brian Steele. It's damn near just as good as Drew Fillon. But what about the other lawyers? These are Fed lawyers. These ain't regular ass lawyers. Fed lawyers, even public defenders, are actually decent. So now we're sitting back going, well, it look bad. It do look bad. But a collective? Man, that can't be bad. For the defense, that can't be bad. Now, the prosecution ultimately wins. And here's why Lil Durk is ultimately being hit with bad news. Durk is like, let's go now. I know y'all don't have half the shit y'all talking about. The theory that y'all have, all 3 of your theories keep on crumbling. So once we do this, then we're good to go, because they have to file motions. And if they don't like the way those motions are, they're going to try to go to higher courts and all of this shit. So if I'm Lil Durk, I'm going, all right, well, shit, what's the game plan? The game plan is, let's get these motions. Let's try to get these plane tickets thrown out. Let's get this thrown out. Let's try to pressure the freaking judge. Brian, what you got, man? Because I was thinking like this and this and this and this. Brian will probably confirm, be like, yeah, I hear you with this. I hear you with this. But when I got it my way with this, I tried this approach right here. And Brian being a new face in there brings the morale up and brings a different idea. But the same thing with the other freaking lawyers. See, we had to remember this and this alone. There's other defendants. Yeah, Durk is Durk is fighting a freaking life sentence for sure. But they put in a backdoor ass way to get him time. They put in a stalking charge. So if I'm Brian, if I'm Drew Fillon and I'm Brian Steele, I'm working like hell to get the stalking charge removed. They still haven't ruled on that shit. I think it's Asa Houston's lawyer is whooping the shit out of that shit, and nobody's talking about him. You don't need to be all high powered and shit. Sometimes we get stars born in the moments in trials like this right here. Like Nicole Westmoreland, she was a star when it came to the Diddy trial. We knew her through the Bruce Harvey and YSL trial, but she went to the Fed shit and did her thing because she knew certain ways to attack certain shit, and her story was just as crazy as things that happened to her in the past to bring it here to relate, and why Sean Diddy Combs ain't get smacked with hella years. Granted, he got smacked with a couple, but the takeaway from this video that we all should have is the feds letting this shit happen means the feds are treating this like an active investigation still, which means the feds will still try to introduce evidence that they find, which means whoever is eating the cheese, all these cats that are eating the cheese, bruh, that's bad. Because one of the things that can happen, which I doubt it would, is I would, if I'm a prosecutor, I'm going to the driver. And I'm basically saying, listen, man, we're going to give you 30 and you just give up everybody else. If I'm gonna attack somebody, that's how I would do it. I would go, shit, let me get the driver out of here, because the driver is the one who put all of this together. But the driver was second in command. They said Durk is first in command. So why don't I get your second in command to flip, and then we good to go? Now, some of you are like, oh, no, Sonny Dash, don't give the feds ideas. Do you really think I'm smarter than the feds? Bro, I graduated from a continuation high school where if you fought at that school, you're going back to the hall. This was the school that you came to when you got out of juvie. So, miss me with the ruckus bullshit. And it's just a theory. Not a goddamn prosecutor. I'm a hood lawyer. But hey, y'all, let me know y'all thoughts on this video. What y'all thinking for Durk? Are y'all with me like, yeah, technically this is bad? Or like, nah, hell nah. This gives them a chance to do the motions and then try to go over the judge's head. Either or. Let me know. Hit that like button like you like. Some 23K away from these two things being given away. Click right here, though, to see how Ray J is going to mess around and get himself canceled by the Booty Goons. Click right here to find out all about that, or click right here for the playlist. Now, catch you on the next one.